Welcome back to Open Line. We have with us Barbara Boone McGinnis, elder law attorney, talking about all kinds of things. If you're caring for an elderly loved one, or you yourself are facing questions about what to do about the cost of nursing home care or just estate planning, wills, that's a big thing. I'm always interested in this whole conversation about wills and how contentious they can be. Right. Because sometimes someone will die, there's not a will, there's a big fight. Sometimes even with a will, there's a big fight. Right. So kind of what do you tell people about having a will and how that can just make things much easier?
Having a will does make disposition of assets at death easier, even if you do not have a probatable estate. A lot of times people spend a lot of time worrying about probate. Is my estate going to have to be probated? And again, that's going to court to admit your will that says this is the way, you know, the decedent wants their assets distributed, and I promise this is the real will. Sometimes people think if you have a will, you don't have to probate. Right. Well, wills are really nothing more than a written expression of your desires until it goes to court, and then it's given legitimacy at that point in time. But it lets you have control over your assets and where they're going to go when you die. I think that's important. I think a lot of people think that's important. Even if your assets would be distributed by a way other than a will, beneficiary designations, PODs, joint tenancies, all the other ways that you can pass assets, a will is still a memorialization of your intention. Who did you want to honor and remember, and in what sort of ways? So I think I think wills are a good thing. You know?
So let's say someone dies, they don't have a will. Mm-hmm. What happens? What's the process? They have no will. What's the process?
First thing you do is look to see how their assets were titled during their life. A lot of times married couples own things together, so a will becomes not as necessary because the asset is jointly titled. We usually own our house with our spouse. We usually own bank accounts with our spouse. So we look to see how how the assets of the deceased person is titled. Are there beneficiary designations? Insurance, retirement accounts, they often pass by beneficiary designation. So we have to notice these places, these financial institutions and companies, to let them know that someone's passed away. Death certificates are necessary, documents, they send you the packet, fill it out and send it back. So a lot of paperwork. And then the check would go, or the distribution would go, to whomever's named as the beneficiary. And that's okay as long as you didn't forget to change your beneficiary designations after a divorce or something, because the beneficiary designation trumps.
So yeah, that is probably something that happens, right?
It does. So
you are at work, you fill out a beneficiary designation for your wife, then it's just there for years and years and years. You get a divorce, and you forget remarry, to change. Yeah. And that money would go to the old beneficiary, no matter what. If you
didn't update it, it would.
Wow.
So I think a lot of times people don't understand how assets pass. You know, a will doesn't control everything. If you say in your will everything goes to the new wife, but you didn't change the beneficiary designation, it's not going to happen. You know?
So that would even trump the will.
You're right.
Oh, that's very interesting. Okay.
So it's real important to keep track of those. Mm-hmm. Have a contingent beneficiary in case the primary beneficiary passes before you do, so that it doesn't just lapse into your estate. But I think what you were really asking is there a place for my stuff? You know, if I'm just holding a whole bunch of assets in my name only, and I die, what's going to happen to my stuff? And every state has a set of laws called Intestate Succession. So if you die without a will, that's being intestate, and the succession plan for the assets in those circumstances. So if you're married, your spouse gets a share. If you have children and you're married, your spouse and your children get a share. If you're
automatically, right?
Right. Right.
So you have no will, and there's actually a calculation for how that all is divided.
There is. Again, after we've dealt with stuff that's jointly held, stuff that has beneficiary designation, what's left, then we look at spouse, children, parents, grandparents, brothers and sisters, and then it just goes out and out. So you're almost guaranteed to have a place for your stuff when you die. The question is it where you would want it to go?
So there are these laws that designate where things go without a will.
Right.
Some things, you're married, they're going to go to your spouse.
Right.
No spouse, I guess it goes to your
Children.
kids.
Yeah.
All right, let's say you're married and you have a will and you say, I don't want it to go to my spouse, I want it to go to my kids. Is your spouse entitled to something?
Absolutely.
So you can't do that. You couldn't cut your spouse out.
You can't really disinherit your spouse in the absence of having some pre-nuptial agreement where you both waive that right to elective share. It's actually called, your spouse will share your elective share. So if you've been married a certain number of years, you're entitled to X percentage of the estate.
Oh, interesting. Okay. Let's go to Pat. Hello, Pat.
Yeah.
Go right ahead.
Long-term health insurance. My mom's had a policy for years, and about 2 years we tried to make a claim on it, and we're denied. And her main problem is real bad dementia.
Okay.
But, you know, she can go to the bathroom by herself, feed herself, but, you know, I have to take care of getting food there and medicine and all that stuff. Do they just have a sort of a blanket policy, let's deny the first time and make you come back and go through the process again?
How long have you been paying on it?
Over 10 years.
Wow.
Yeah.
And what's the age? Do you mind? Did you say that? How old?
81.
81.
Goodness.
Okay. See, that upsets me. I'm
Right.
That really actually upsets me. So here's a law. I mean, they should pay, it seems to me, but I don't know. These insurance companies.
So I think a lot of times consumers share his sentiments and wonder, do they have a blanket policy about denying on the first time out? Because I hear that a lot from families. The first time that they claim on these policies, they're denied. And it requires some persistence and requests for reevaluations. It also is based on policy parameters. So if your policy says you have to have a certain number of activities of daily living impaired before it's going to pay, activities of daily living, bathing, dressing, feeding, toileting, transferring, those kind of things. If your policy is only limited to these activities of daily living limitation, that's fine. Most of the time they have a dementia factor as well. Like you're either significantly physically impaired or you need care related to your level of dementia. So that's usually in the policies, but you would look at your policy parameters. And then it may take just persistence in applying and getting to and requesting a reevaluation of mom. The other thing that sometimes you have to be incurring some sort of expense for them to pay for care. So you're either paying for care in a custodial care facility, an assisted living facility, or maybe you're paying for care in the home setting if your policy provides for that. So some older policies didn't have these alternative care settings like assisted living or care in the home. It was just for nursing home care. So those would be some of the things to look at. It's also some of the things to think about when you're buying a policy to make sure that it covers care in all these different settings.
But what Pat is talking about is not uncommon, that someone will go to claim it and it'll be denied.
Yeah.
And so you have to be persistent.
Yeah.
So that makes me think, that infuriates me. Just that would be a roadblock, an impediment to even dealing with it. Because he's paid for 10 years at least, an 81-year-old. That's unfortunate. Pat, did you have anything else to add? I think he may have left. Okay, thanks for that call, Pat. Let's go to Corey. Hello, Corey.
Yes, I've got a question that I'm dealing with now. I was the caretaker for an elderly relative for the past few years, And then the will that she made, it left the estate to me. However, apparently there was beneficiaries listed as payable upon death on some of her accounts that were from several years ago and some even decades ago. Does the will overrule that, or does it go to whoever's listed on payable upon death?
Yeah.
I think I know the answer to that, but what about that?
So it's exactly like what we were just talking about, that when you have these payable on death designations or a transfer on death designation, that's just like having a beneficiary designation on a life insurance or retirement, and it will trump the will. Yeah.
And there's
sad.
nothing that can be done about it. There's no reason to fight that. It's just the law. And it's probably an oversight.
Could be.
It's probably an oversight.
She may have set up bank accounts a long time ago and listed someone as a payable on death and forgot all about it. But it's, it's still valid, and that's what the financial institution is going to rely on.
All right, who's on line 2? Who do I need to go to there? Vicky, okay. Hello, Vicky. Are you there, Vicky?
Maybe it's Barbara.
Is it Barbara?
I was talking about giving the house to the kids. I gave the house to the kids, and I have an estate.
Okay, go ahead with your question. Go ahead.
Okay, I want to ask this question. My husband's dead, and when he died, we had a lawyer to draw up for my 2 kids to and put their names on the house, and I have a life estate. Okay, if I have to go to a nursing home, can they touch my house if I have just a life estate?
Oh, that's a great question, because I think that's one of the primary fears that people have, or at least that they express to me, is that they worry about what's going to happen to their house if they need nursing home level of care. First of all, the nursing home really doesn't want to own your house. The nursing home just wants to be paid for the care and services that they provide, right? And so I think what she's really talking about, would the state of Tennessee have a claim on her house? Would they put a lien on her house? Well, the state of Tennessee does not put a lien on property. However, if she uses TennCare benefits, is there a possibility of TennCare recovering from her estate, which would be her home, at her death? And under current law, the way she's structured is pretty good, because depending on when that happened in relationship to when she needs nursing home level care, the life estate actually extinguishes at her death, and the house is then owned exclusively by her children at her death. If that transfer occurred greater than 5 years prior to needing nursing home care and TennCare benefits, then the transfer occurred greater than the 5-year look-back period, so she's okay there, and the state cannot attach to a life estate.
Now, when Tim Takis is on here, he says it is never a good idea to give your house to your kids.
Yeah, that's
what I
we believe.
That's what I think she's trying to do here.
No, it's what she's done.
Is what she did, because she is worried that if she doesn't, then the TennCare or whomever will take her house. They don't want to own it, but they'll take it and they'll sell it and they'll use the money to pay off the bill. Yeah. So, what about that?
Right. It is rarely ever our practice to convey the house to the children, retain a life estate or not, because, well, we don't believe that you should give away assets until you're absolutely done with them. There's other ways of doing that conveyance. We usually would work through a trust. That would be more protective for the elder and perhaps even the children. But I do know that conveying the house, the remainder interest in having a life estate, is a fairly common practice. It just does not really comport with what we think is a good idea. And she asked me, would it work?
And it would.
And it
would work if it's longer than 5 years.
If it's been greater than 5 years, yeah.
Now, if she gave the house to her kids 3 years ago, goes into the nursing home,
then we're within, the gift would penalize her from receiving benefits, right.
And how aggressive are you seeing the state or whomever it is that's going TennCare? How aggressively are they going after houses to pay off debts with nursing home care? How often do you see that, and how aggressive?
They are consistent, and I would say reasonably aggressive. Yeah, it's pretty pervasive that they're going to an attempt. And of course, by law, they're supposed to be that way. Because it's one of the conditions of receiving federal dollars for the TennCare program. There are certain exceptions to estate recovery, like being survived by a spouse would be an exception, being survived by a disabled child is an exception, and sometimes there's even such a thing as hardship. Hardship's very difficult to prove, but it would be a family member living in the house that there was no place else for them to live. So you get some deferment. Being survived by a minor child as well as a disabled child, those are exceptions. You can imagine some families fall into those circumstances, and it would be applicable.
That's a fascinating question. I'm sure other people have that same question. All right, we're going to take a break. Wayne and others, hold on the line. We'll take a break. Be back right after this.